Sometimes like all you want to do is run. Hear me out, hear me out. If all the things you never show, there are the things I want you to know. Secrets die in your heart to slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never show. There are the things I want to know. Secrets die in your heart to slow. But if you don't want to tell me now, I guess I'll never know.
Okay, hey guys, welcome to the live. Sorry we're running late. Travis is here. He's just going over the documents. Fran Gall's response just came in as he was looking at the first documents there, which is here. Let me scroll back up just so that people can see it. Okay. Okay, so this one is the Indiana Attorney General's response to Relator Richard Allen's petition for writ of mandamus. And then the other one came in. Thank you, Adam and Charmaine, for sending these to me. By the way, just so you know, Adam and myself will be going on the Drunk Turkey show tonight. So this will be our live here for today. And other than that, we'll be on the Drunk Turkey show at 5:30 Pacific and 7:30 Central, and that would be 8:30 Eastern Standard Time. So we're going to go visit the boys over there. And yeah, so Travis is, just like I said, looking over the documents quickly. So I'm just going to sit here and say hi to you guys. Let me just take a look. Hold on. The brief. The other one is the respondent's brief in opposition to the realtor's verified petition for writ of mandamus. Again, so let's just do our niceties, eh, Charmaine? She's at work. Most people are at work. Hi, Sharon. How are you? Hi, Ben. Ben in the wrench. If you guys could please hit that like button for us as well. Obviously, it's always a bonus that Travis can join and explain things and stuff and talk better. Sorry, I'm a little under the weather today. So this only halfway here. Hi, Daisy. How are you? Amethyst. How are you? Such a pretty name, eh? Pretty flower too for this one. Hi, Miranda. How are you? Gail. Gail's in the house. Mustang, thank you for the 6 tacos that you sent earlier today. It's a very good friend. Very good friend. Thank you so much for that, Mustang. I think that's about it right now. And then, like I said, so Drunk Turkey show, 8:30 Eastern Standard Time. And whenever Travis has looked over the documents and comes back to us here, then we'll get into it. Did you read the whole thing? Well, you're a better person than me because I haven't read nothing yet. I was literally just, I think I'm blurry. I was literally trying to nap for a long time because I was up most of the night. I was thinking that maybe it would come in early in the morning. It's up like 7. Sorry, I'm just trying to get my camera thing properly. But no.
You sent me the same thing.
Did I send you the same? One says Indiana Attorney Generals, and let me see. Let me see, Travis. Oh, yeah, I think you're right here. It's because I got sent like 5 of them, and they all seem to have like almost a different name. So give me 1 second. 1 sec, guys. Okay. Okay, well, which one is it then? Because there's all these different response brief. I think it's this one. Yeah, this one here. Okay. Sorry, Travis. Go back to my thing. Compose.
And then who's read the whole thing?
Oh, Miranda Lee said that in our chat. Okay, well, I thought I sent you this one. 1 second here. Open. Send. Well, it's the same thing. Briefs respondent.
Yeah, it doesn't matter to me if they have different
No.
file names. I just
This
it's
one-
the same document.
This one should be different. The one that I just sent.
Okay, it's we want something different than the Attorney General's response. We want respondent's response. Respondents are Carol Swift Court, Counsel, Francis Siegel.
Oh, Travis, are you talking to yourself? Because you're not coming in very clear.
No, I'm talking to you.
Oh.
I don't know why it's not coming in clear.
It just wasn't. It was almost like your face was down and it was like kind of mumbly. So I wasn't sure if it was your mic or if you were just maybe looking down and talking.
Yeah, no, we're looking for the respondents.
Yeah, that's the one. You should have that now.
Okay, let me look. And then you're going to want to, that's the one you're going to want pulled up.
I have that one pulled up now. Respondent's brief. Again, apologize, guys. Just this document just came in like within 10 minutes ago for this one. The respondent's Frankel.
Ay, ay, ay.
Does Travis need a coffee? I don't know. A little stronger than that, probably.
It's not opening in my Adobe. I don't know why.
Oh, really? I mean, it's like
opening in my preview. Hang on.
Okay.
Try and do this a different way. Save as.
Hi, Danny. Hi, famously, I'm famous. Everyone, please remember to stimulate the algorithm. Thanks, Danny. Yeah, I could use a vitamin C upload probably. So for anyone that's just coming in now, like I said, Travis, like the respondents one from Franco just came in just like literally minutes before the live. So Travis is just trying to take a boo at that one before we get all started and into it. So there's two that came in, the Attorney General's response and then the respondent's brief, which is the Fran Gull one that many of us were waiting for. Hi, Wonder Girl. A brief has been filed by Judge Gull for the writ just now. Is that separate to this one? Or is that the one I have up on screen? Hi, Babs. Oh, can you by chance send it to me, Wonder Girl? Thank you. Thank you, Daisy. I have the Attorney General's. Yeah. And then this one right here, the respondent's brief. So are you saying that another one has come up? No, well, I did have that one up a minute ago, but we haven't gone through it. Okay, so just these two then? Okay. Yeah, we have. Hey, Adam. Adam's at an appointment. I'm not sure if he's still there or not.
I guess just start reading the introduction.
Okay, so for Fran Gull's one here, right? Okay. Let's see here. Scrolly. Okay. So this court has never issued a writ to reinstate a criminal defendant's counsel. Oops. Thank you, Catherine McDaniels, for subscribing. Whoops. My bad. Thank you. Okay. So let's try it again. This court has never issued a writ to reinstate a criminal's defendant's counsel whom the trial court removed from engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying Relator's counsel, respondent did not violate any absolute duty. Moreover, Relator's remedies on appeal are wholly are adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether Relator's counsel withdrew or were removed, this court should deny the petition. Relator's petition further fails on the merits. Relator's Sixth Amendment right to effective assistance of counsel outweighs his limit right to select his counsel. Respondent has a discretion to remove Relator's counsel where, as here, the record supports that attorneys Baldwin and Rosie were providing ineffective assistance of counsel. Relator's counsel failed on multiple occasions to take reasonable steps to safeguard confidential case materials, made extrajudicial statements that had a material likelihood of prejudicing the case, and 3, provided false information to the court. Before removing Relator's counsel, respondent afforded Relator with notice and opportunity to be heard through written submissions as well as an argument in chambers on the record in open court. Relator's request for this court to disqualify respondent fails because respondent alleges no bias or prejudice against Relator or his current counsel. Relator's lone assertion for respondents' removal in the trial court's ruling to disqualify Relator prior counsel, but a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. Do you want me to stop there and you? Did you want me to stop there, Travis?
Yeah, that's good. Trying to pick out here what's, of interest. Go down to standard of review.
Yeah, I'm on that right now.
Middle of page 7. So we've been talking about these original actions that they're called in Indiana when a party files a petition for writ of mandamus prohibition. That's an original action, and they're extremely limited in what they can do. Writs of mandamus and prohibition are extraordinary remedies which, quote, are viewed with disfavor and may not be used as substitutes for appeals. Then it says this court will not issue a writ unless relator has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act. Then argument number 1 towards the bottom of 7. Relator does not have a clear and unquestioned right to have his counsel reinstated. This court, the Indiana Supreme Court, has never issued a writ to reinstate counsel, whereas here the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused constitutional right to competent assistance of counsel. Contrary to Relator's assertion, neither this court nor the U.S. Supreme Court has held. I'm on to the next page.
Yeah.
Overrule or may remove an accused selected counsel in 2 circumstances only, where 1, counsel is not a member of the bar, counsel has an actual conflict. That was case law cited in the Relator's brief. They cite a couple of cases to the contrary, and I'll have to pull these up and look them over when we have more time. State ex rel. Jones v. Knox Superior Court denied the relief Relator requests here. It's a 2000 Indiana Supreme Court case. And then the Relator, who had been indicted for murder and rape, requested a writ of mandamus to reinstate his attorneys who had been removed. The court denied the petition. In dictum, the court observed there was generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. The court denied the petition. In dictum, the court observed that it was generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the parameters of the authority here. So they're saying it's disfavored, but there's no Indiana Supreme Court case that talks about there being an absolute right, a clear, unquestioned right to relief or established that respondent violated an absolute duty. Then they point out Relator relies for the most part on cases from outside Indiana, which we've talked about before, and that when interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Relator identifies no case from this court or the U.S. Supreme Court that affords him a clear right as to extraordinary relief for the relief he seeks. We knew that was going to be the main thrust, and there it is. Now, it's interesting that 23 some odd years ago, the Indiana Supreme Court was mentioned that it disfavors removing appointed counsel, but they just didn't dig into the real nuts and bolts of it. They didn't have to, and I'll read that case later and find out why they didn't need to really look into it for purposes of that particular writ. But that doesn't mean that they may decide this is the right opportunity to dig into that. B, Relator's remedies by appeal are wholly adequate. So this, I think, we'll see. I'm reading here where they get down to the gist, and now I'm over to page 10. Relator asks this court to use an original action to rule on the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. That's interesting they put that. Sure, we're going to see if they seek to file a reply to this brief, they have to seek leave of the Indiana Supreme Court to file a reply and attach a copy of the reply, which I assume they're going to do. They did that on the first writ. And I'm sure they're going to talk about the manner of these quote findings. Relator asks this court to use an original action to rule for the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. Reasonably found. That's probably going to be the subject of a lot of discussion in the reply, but this court will consider an extraordinary writ only when the law is settled and the trial court's duty is absolute. Now, the case they cite, and again, I'll go back and look at that, they didn't have to dig into when it's reasonable for a court to remove somebody, and a court-appointed attorney. They did mention that they disfavor removing a court-appointed attorney. So the Indiana Supreme Court's going to decide whether the facts of this case and this issue are appropriate to address those questions now, or save them for a later time. Now, of course, this has always been a matter of concern that if there wasn't an interlocutory appeal available, which it doesn't appear that there is, because Judge Gull would have had to have agreed to that. So they went with this petition for writ of mandamus, an original action in the Indiana Supreme Court. And if the Indiana Supreme Court says, no, there's no absolute duty, so we're not going to hear it now, that means this whole thing could go to trial. And if there was a guilty verdict for something against Richard Allen, that he would then take it up on appeal then. And I don't think that would be satisfactory to anybody except the Attorney General, apparently, and the position taken in this brief. They're saying you've got an adequate remedy, you can appeal it after trial. Roman numeral 2, the trial court did not violate Relator's Sixth Amendment rights by removing Relator's counsel. Now they're getting more into the merits, what was argued in the petition. Criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense, citing Wheat, which is one of the landmark cases on that, 1988. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure a defendant will be inexorably represented by the lawyer whom he prefers. Respondent properly exercised her discretion to protect his Sixth Amendment rights. As this court has explained, I'm at the bottom of 10, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. I'm over on the top of 11. The appointment of pauper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. In that case, talked about appointment, not removal. The qualified right to choose one's own counsel must be placed against the backdrop of judicial discretion. And then they cite Danitz, saying it's within the discretion of the trial court. The trial court is granted considerable discretion to remove counsel, so the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. This court has explained that the trial court must be given latitude in its efforts to navigate, their citing Greek mythology posed by the conflicting Sixth Amendment rights to counsel of one's choice and a competent counsel. So there's an conflicting intersection between the right to counsel and the right to choose counsel. Lotta, and they cite this case, Harling, gross incompetence or contumacious conduct that cannot be cured by a citation for contempt may justify the court's removal of an attorney even over the defendant's objection, citing Harling, which is a non-Indiana case, citing U.S. v. Danitz, Fifth Circuit case. That's where I'm in. but I think they're going to argue that this is something that could have been cured by a citation by contempt. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire court trial proceedings to be constitutionally defective. Where they're going to have problems here is the grounds cited in the transcript. None of those really go to the representation of Mr. Allen. They go to perceived violations of protective order and a gag order. So, there's going to be a response to that. So far, they haven't cited any clear cases saying that she's allowed to do it. So then at the end, we're over on the top of the next page, which is
12. You just
Let me
finished
find
11.
out where I'm at. Top of 12.
Yeah.
U.S. v. Howard, affirming disqualification of defense counsel on the grounds that the trial court has an obligation to foresee problems over representation that might arise at trial and then head them off beforehand. Case just isn't applicable to violations of a gag order or violations of a protective order. So that's going to be a big question if the Indiana Supreme Court decides to get in the merits of this, whether they see a difference between protective order, gag order violations and actual representation. I'm reading through here to get to something substantive.
Okay.
Let's see. Respondent acted well within her discretion to remove Baldwin and Rossi over Rick's objections. The record supports that the trial court could reasonably conclude Baldwin and Rossi committed multiple violations of the rules of professional conduct. I don't know where they get that. Compromised Relator's defense. Don't know where they get that. And that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. I would think if these are examples of that, they would have said by the following. But anyway, number one, failed to take reasonable steps to safeguard confidential case materials, including crime scene photos, I think that Indiana Professional Conduct Rule 1.6, comment 16, I'll need to look it up, and 1.15a is going to be preserving client's property. That stuff's not the client's property. So they're saying failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. They talk about Baldwin and reviewed photos, took pictures of those photos, shared them with at least one other unauthorized person. Footnote, they filed the transcript of October 19th, in-camera meeting with counsel as a supplemental record in response to a relator's motion for transcript and in compliance with the court's orders dated November 8th and 9th. Going back to this first point in support of the findings, the photos leaked over to the next page to the public, which prompted the police to investigate. Rozzi understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Waterman's feedback. Don't know if that's supported in the record on page 214 or what that is. Baldwin emailed confidential work product to an unauthorized person. Baldwin and Rozzi failed to timely report that. Baldwin and Rozzi made extrajudicial statements that had a substantial likelihood of materially prejudicing the case. They included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed Relator's innocence. They didn't limit it to what Rule 3.6b provides. In number 4, Baldwin and Rozzi provided false information to the trial court. On or about June 20th, the trial court held a hearing on Relator's motion to reconsider safekeeping order. At the hearing, the state presented evidence that clearly demonstrated the falsity of Relator's claims. The trial court issued an order on the motion, finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates. As a result, so I don't know if they covered that, but I'm sure you're going to see responses to all of those if they choose to file a reply. It's interesting that they, in these 4 points that they've listed, that they're digging into the facts behind the findings. Remember that the judge read off several things in the in-camera meeting. And that she said, if you don't withdraw, I'm going to go out into court. I'm going to read these off and I'll remove you either way. And by listing these 4 things, that's going to give an opportunity for Rossi and Baldwin to be much more fact specific about it and get the full facts on those things out. Whereas right now, before this filing, what it was limited to, okay, was the standard that she found gross negligent? Is that the right standard? Do they have the discretion? So they've chosen to get into the nuts and bolts of each of those things she listed, at least 4 of them. Those 4 events, the judge is saying constitute gross negligence and give her the discretion to remove them. And by going into them a little bit and saying what they say, it gives Richard Allen an opportunity to go in and argue the facts of those. The record demonstrates that the trial court, based on the totality of the circumstances, could reasonably conclude that counsel's representation of Relator fell objectively short of the prevailing professional norms, that counsel's deficient performance prejudiced the defense in violation of Relator's Sixth Amendment right to competent counsel. And, you know, there's going to be an argument about that from the other side, that none of those things go to the defense. If they had the same complaints about the Frank's memorandum, you know, that would have been mentioned. That really is his, goes directly to his defense. These other things are collateral, may or may not go directly to his defense, but nothing has really prejudiced the defense by violating a gag order, by exceeding the rule, allowing a response, but, you know, we'll let Kara respond to all of that. Let's see.
Travis,
Counsel's performance was deficient based on prevailing professional norms. Normally, you need an expert to talk about that, or you need and these are the standards out of Strickland also. In order to get a case reversed for IAC, you need to show, 1, performance was deficient based on prevailing professional norms, and that the other part of that is that it wasn't strategic, and that the deficient performance prejudiced the defense. It's usually that second prong, which is referred to as the materiality prong. So they're saying failed to safeguard confidential case materials, provides false information to the court, but they don't detail what was false. They have a conclusion that the court's finding. That's kind of interesting. That kind of opens up in a reply that the court the court's biased, and it's the court seeing things that it's not really seeing. Surprised they didn't detail that out. If there was false information provided, all they really, and again, I'm skimming this. So going back up to page 14,
Okay, Travis.
point number 4, Baldwin and Rossi provided false information to trial court. They held a hearing on the motion. At the hearing, the state presented evidence that clearly demonstrated the falsity of Relator's claims. Well, that's just what they are. They're Relator's claims. And like, that's what attorneys do. You present claims, and as much as you can, you attempt to relate claims that you can back up with documentation or testimony. The trial court issued an order on the clearly demonstrated the falsity of Relator's claims.
Sorry, Travis, what page are we on? I thought you said 14, but I thought we were down to 16 already. What page are you on?
No, I said go back to 14, number 4.
Oh.
I'm trying to figure out where they're saying that they've documented, because they haven't documented anything here. They've got an order saying the state presented evidence that clearly demonstrated the falsity of Relator's claims. The trial court issued an order on the motion finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant's counsel. The evidence presented at the hearing did not support many of the allegations advanced. I don't know the details of that, nor am I going to dig into it, but that doesn't mean an allegation is false. They're saying provided false information, did not support many of the allegations. That could be for a lot of reasons. A witness didn't show. They could have been clear that based on information and belief, which is a proper way to allege something, because you don't have access to a particular witness or documents maybe, and so you allege it on information and belief, then it doesn't turn out to be that's the case. That's not providing false information. So what I'm looking for here is this false information, and they don't set out specifically, like, for example, they said these people were a member of a particular cult. The jailers were the member of a particular cult, and no evidence of that whatsoever. They're not detailing that. Let's see.
Can I ask you a question from Adam? He says, Travis, the court is under no obligation to allow further responses by the realtor to the respondent's response, correct? They allowed it the first writ, but stated that wasn't common, right?
Oh, it's quite common. It's how the amicus were done. So I'm pretty sure you're going to see a reply to this response. Yeah. And it's up to the Indiana Supreme Court to rule on that. But I suspect they'll grant a reply if one's filed, and if they're requested to do it. If it happens within the next couple of days, and then you have to attach the response, the full reply to the motion for leave to file it. So it's kind of out there anyway. But I would suspect they're going to go ahead, if it's done timely within the next couple of days, that they would go ahead and grant it. And the court's pretty quick about doing that. So now I'm back to 15, and based on the totality of the circumstances, could conclude the counsel's representation of Relator fell objectively short of the prevailing professional norms. And it talks about those two requirements. Let's see if they establish that. Professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information in the court, which they haven't really brought out, makes extrajudicial statements that are likely to prejudice the case.
Yeah, I'm not really sure what they're referring to. Do you guys know, Adam? Because about the
we don't need to be guessing. It should be right in here in these things.
Yeah, I just don't recall like.
Yeah. So 16, the total. The trial court afforded Relator adequate notice and an opportunity to be heard. Okay, this should be interesting. Relator argues that the removal proceeding should occur at a hearing where the defendant and his chosen counsel provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. Brief, page 16, citing Tennessee case. Relator cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. In any event, the record confirms that respondent provided Relator with ample notice that the trial court was considering disqualifying Baldwin and Rosie before October 19th. On October 11th, Relator wrote a letter to the respondent requesting that Baldwin and Rosie continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rosie's disqualifications. On the morning of October 19, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Relator had adequate notice and opportunity to argue against respondent's disqualification of Baldwin and Rosie. And they filed new appearances over to 17. And afforded them an opportunity to be heard on the record, including Baldwin's counsel, which is Hennessy. The trial court afforded Relator adequate process. So no surprises there. Roman numeral 3, Relator's request for this court order respondent's disqualification fails because respondent has shown no bias or prejudice towards Relator, his current counsel, or his former counsel. So first argument, if biased against him because of his former counsel. The first argument is it's not an issue because those counsel no longer represent him. Doesn't assert that there's any personal bias or prejudice towards himself or his current counsel. And that on the merits, meaning if the court wants to look into it, they present no relevant facts supporting Relator's assertion that respondent is biased or prejudiced against Relator's former counsel. Then at the bottom, they cite why a court shouldn't disqualify itself unnecessarily, and cites a code of judicial conduct rule. The next page, they cite the law regarding disqualification of a judge. And then sub-argument A, Baldwin and Rossi no longer represent Relator, and Relator alleges no bias towards himself. Removed from representing on October 31st. Appointed new counsel. Given that Baldwin and Rossi, over to the next page at the top, given that Baldwin and Rossi are no longer counsel record, Relator's sweeping assertion that for all rulings going forward, the public will question the judge's impartiality and that a new special judge must be appointed to restore the public's trust in the integrity of the judicial process amount to blind speculation. Sub-argument B, Relator fails to show that respondent has actual bias or prejudice against Baldwin and Rossi. Even if they still represented, has exhibited no actual bias or prejudice against them. Officers scant 2 sentences to support his assertion. Then they cite a case, but a judge's findings adverse to a party, talking about findings of gross negligence on behalf of the attorneys, do not show or imply bias or prejudice. So just the mere fact that you rule against a party doesn't show bias. Got to be something more. Respondent did not state that she had grave concerns about Baldwin and Rossi personally. Rather, she had concerns only about their representation of Relator and his right to competent representation. Legal findings regarding Baldwin and Rossi's representation are insufficient to overcome Indiana's law presumption that respondent is unbiased and unprejudiced. Next page, Roman numeral 4, trial court should deny requests to reinstate the trial date. The court should deny relator's request to reinstate the trial date. Relator requested the continuance. Relator requests this court to reinstate the 24 trial date, but relator's counsel requested the trial continuance because counsel will not be ready to try the case in January. Respondent did not violate an absolute duty by granting relator's own motion. Should deny amicus request to refer appointment of replacement counsel to the state public defender. So this is their response to the Indiana Public Defender Council's amicus brief that said there's problems with the way she appointed the 2 new attorneys. Trial court's appointment of relator's current counsel was procedurally defective, but relator raises no objection to the respondent's process for appointing new counsel to replace Baldwin and Rozzi. Amicus may make arguments in support of relator's request for relief, but the court should not entertain amicus's separate request for relief. Well, the briefs were filed on the same day within a close amount of time. So I'm sure that's going to be in the reply if one's filed, that the process should have been followed the way that amicus said it should have been followed. Neither IPDC nor relator assert the relator's newly appointed counsel, one of whom is the IPDCV notes, and is Allen County's chief public defender, is incompetent, merely claims that the trial court circumvented the county's comprehensive plan for public defender assignments. However, the trial court, this is important, has discretion to appoint counsel other than counsel provided for under the board's plan when the interest of justice required, citing a statute. And that the appointment in that fashion didn't violate law. Conclusion, so that's it on that, and no real surprises. They hammered hard on really hard on the procedural part of it, that there's no absolute duty, which is required for a writ of mandamus, and so that was to be expected. Didn't go into much detail on the merits, those things that the court found to be gross negligence, and then covered the notice and opportunity. So that's it on that. The Attorney General also filed a brief, and it doesn't really have anything different than what's argued here. So I don't think we need to go through that separately. But they also argued strenuously that there's no absolute duty and it's not proper for an original action, a petition for mandamus. So we got any questions?
Well, okay, let me get one in because Adam sent me this long ass message in my messenger. Let me just read it to you, and then if you could answer. It says, will you ask Travis if one reason the Attorney General chose to get involved with this writ versus the first one, is it most likely because they declined it in the first mandamus because the issues weren't as pertinent to the state's typical foundation? But in this one, they are trying to change the standard for when defense counsel can be removed. It implicates, and more important and impactful, state interests. Okay, that's a load full of. I hope you understood that.
Yeah, I think I do.
Okay.
Well, the first one, yeah, I don't think they were filing. I don't think they filed a response to that one because, and maybe what was problematic for them, and they didn't want to get involved in representing the court, is they saw clear violations of the ACR rules, and that one was filed a couple of 3 days before this one. They saw clear problems, and who knows how that thing went down, but they told her, we can't represent you on that one. And, we don't know why, but for sure, but there could be a couple of different strategic reasons. One is they saw clear violations and they weren't going to try and defend the court on that. So we can't take a position agreeing with, for example, putting stuff up on a website satisfies the rules, or how you handle redaction, or your position on a deceased person's name versus initials. We've taken a contrary position on that, and or they may have said, for strategic purposes, it would be better if you got your own lawyer, and then we'll get 2 bites of the apple. We're able to file a brief on behalf of the state, even though we're not a respondent, so we'll be able to file 2 briefs. So it's impossible to say, but the first petition and the second petition, issues are completely different. The court was clearly wrong and tried to moot it with her order. What's left on that is the court, the respondent believes everything was taken care of by the order that was entered, directing the clerk to do different things, and then submitting a response saying, everything's been taken care of, and this is all the clerk's fault, and, but I've gotten it all taken care of. Then they filed a motion for leave to file a reply. The relator did, Rick's counsel, through PFD, and did this chart saying, well, you fixed a couple of things, but there's still 8 other things that are a problem. And, it's concerning and troubling that this is going to continue in this case. And then, so could be a few different reasons why the state didn't get involved in the first one. They may have said, yeah, we admit we messed up on that and we're going to do what they ask anyway. And so they wanted to take this position. So the Attorney General comes in on criminal cases. They can come in on any criminal case, even though they're not the named respondent. And on felony cases, the AG is who normally handles direct appeals. So that way they can have a consistent position around the state in the Court of Appeals, because there's several. I don't know how many there are in Indiana, but there are multiple. You don't want, in a criminal case, to be arguing something in one appellate court that's completely different in another part of the state. So that's why you don't have district attorney's offices handling those appeals. They all get kicked to the AG's office, and then the district attorney's office assists the AG's office with the appeal. So I don't know that they got involved because there's any compelling issues other than what the AG was most interested in their brief is parties being able to attack, criminal defendants being able to attack decisions by petitions for writ of mandamus, and that this isn't the appropriate way to do it. That's their main concern.
Travis, in the AG one though, remember you were kind of looking for the different things about the falsehoods and stuff like that.
I was looking for it in the brief.
Yeah, you were looking for it in, I guess, the brief.
And it's not in there.
No, in the AG one, it refers to what she's talking about. It's
yeah. I'm looking in this brief here, and then that it's not lining up. So that would tell me that it's clear that they, prepared the briefs together if they talk more about those facts in the other brief. Seven. Okay, 7. Okay, going over from 6. Chambers meeting before the hearing. Judge Gull informed Baldwin and Rossi of concerns regarding the defense team, the totality of the circumstances, outlined her concerns. So they're just outlining what the judge's position was. So is there something else in this where they detail what the false information was? So they're just repeating what her allegation was.
Yeah, but it's just I could think in hers we didn't hear like what exactly the false information was, but here
Yeah, and even less so in this one. So they're just kind of laying out the facts there. Let's see. Go back up to their they kind of mirror each other. Yeah, they're shadow briefs. Nothing really. So I'm guessing it's hard to say who wrote what first, but the other just shadowed it. I mean, the arguments are almost identical, but neither one lays out specifically what the false or inaccurate information was. They're both conclusory on that. Might hear some so we'll have to wait and see for the reply if they do one. That would be in the next couple of days.
I would think that they would.
Yeah, I think there's a lot that they can reply to that I can kind of see already. They need to discuss the one case so all they could come up with really is one case where they denied the removal, but it did go all the way to an opinion. That's important. The one case that they cited and that the court said, although we disfavor removing appointed counsel, we don't need to get into that. So that's going to be a key case. So at some point, we should go through that case and see what was involved in that. That's important because they, rather than just dismissing it and saying it's not appropriate, they said for whatever reasons in that particular case, they didn't have to get into whether it was appropriate or not. So that may end up being a pretty good case for the relator. Hard to say. And, their court's either going to say it's premature and there's not an absolute duty. But there's a lot of things I think that they're going to want to respond to on this. And that'll happen in the next couple of days. And then after that, the case would be what we call submitted, meaning both sides, all sides have been able to submit all of the information in briefs that they wish. The deadlines are expired. There's nothing else that can be submitted. And then the court will render a decision, which I believe there's 5 justices. So if they'll initially read them, and their law clerks will do summaries and get those. They usually have a weekly conference. I'm not sure exactly how it works in the Indiana Supreme Court. Normally they have a weekly conference and they go through things, and so it'll come up at the next conference as, everybody had a chance to look at the briefs on the 2 petitions. What's the initial impression? If it's 5-0 one way, it'll happen real quick because it's pretty easy. If it's 3-2 one way or the other, it takes more time because whoever's in the majority, the Chief Justice, if it's like most Supreme Courts, state Supreme Courts, will assign that to somebody to draft an initial opinion. And that gets circulated, and then people discuss whether they can sign on to that, and you have a majority, or I can't sign on to it with this, but if you get rid of this part of it, I can join it for a majority, and there's a whole process to that. But it takes longer if it's not 4-1 or 5-0. If it's 5-0, that it's premature and there's no absolute duty, that was either done or not done, that was required to be done or required not to be done, then we'll probably have an opinion out pretty quickly. But it'll be interesting to see this 2000 case that got cited, and what the circumstances of that were, and who that ends up looking like it will favor. But if the Supreme Court of Indiana thinks this is something that needs to get dealt with now, then even though there's no cases that have never granted it before, it's certainly tougher to get them to do it. But there's always a first one. There's always a first landmark case. That's why they're landmark cases. There was, a first Gideon, and a first on and on and on and on. First Miranda, first Strickland, IAC. So wouldn't even probably be having the argument if there were 20 cases on it. That's when you need these kind of original actions to find out if there's possibly a remedy. And they're disfavored, so you're always going to see the state arguing that it's premature, because that's just the way you argue against original actions, is that they're an extraordinary remedy and they're disfavored and should be rare. That's kind of the standard. So I think the case, looking in the table of
case,
cases, is
Travis, which one are we referring to? The Knox and Jones, or the case that you keep talking about to look into? I went back to it, but I'm confused which one it was.
isn't it not Knox Sugar?
Knox Superior Court. Jones is not.
God, I need my readers.
It's
Knox,
okay.
yeah. Jones, State XRL Jones v. Knox Superior Court.
Yeah, okay. Just want to make sure everyone knew the right one. And
I
that
thought it said Knox Sugar Co. Oh my God.
Knox Sugar, sure. Close
It
enough.
was an industrial pollution case.
Yeah. So, I mean, basically, it's just a matter of waiting for a response, and then basically, it's everyone's basically had their say.
Yeah,
Yeah.
and I agree with you that, it's fairly certain, I would expect, if not tomorrow, then the next day, that we see a motion for leave to file a brief in response to this brief we've just gone through, along with responding to the brief of the Attorney General. And since the arguments are almost identical, they can do that in one brief.
Ivy Rose asked you a question. She says, what does Travis think about Supreme Court's opinion about the argument that the correct process for an original action wasn't taken and an appeal is more appropriate?
So that's a great question, Ivy. That's the position taken in the court's response, and they cite other previous Indiana Supreme Court cases, but they're not citing anything super specific in terms of removal of counsel. They're citing case law that if you can handle it with an appeal, interlocutory or direct appeal after verdict, that's the way you want to handle it. And so that was the major thrust, and there was no surprise there. As a matter of fact, Kara, the main author of the petition, she spoke on Defense Diaries live about her brief. She even said that, that's always the concern. It's super rare to get a court to grant a writ of mandamus on these types of cases. I'm surprised there's a case out there that actually reached a decision about the removal of counsel. So we'll look at that. But to answer Ivy's question, that's kind of what was expected, and I don't think it's going to be any surprise whatsoever to the other side. And they're between the Indiana Defender Council and the brief, and they've acknowledged So does so actually brings up some interesting stuff. So has the court been grossly negligent in not following the ACR? And if the court has been grossly negligent in filing the ACR, shouldn't that justify her automatic removal? Or is it, yeah, these were mistakes and acknowledged them. I'm blaming the clerk, even though PFD says you can't blame the clerk, it's your responsibility, but and you still have more to fix. But it'll be interesting to see maybe if they analogize the judge's violations of the ACR rules as if they take that tact. But it's tough, it's a real long shot. And I was surprised by a couple of things, how conclusory they were, but we'll see.
Did you answer Charmaine's? And what were they supposed to appeal? She ordered removed from the record. It was clear she wasn't hearing anything from them.
Right. Well, so they're saying, when they're saying appeal, they're talking about, and this is seriously what they're arguing, that no, we can have the full trial, and if he's found guilty, then he can bring it up then. And the court could say, well, yeah, technically that's right, and we agree. Or they could say, well, technically that might be right, but judge, following your approach, we're looking at the totality of the circumstances. We're looking at how this thing got conducted in chambers, and how this happened, and these problems with the ACR, and you not following the comprehensive plan, but you appointing two attorneys from your county. We think we can carve out something that's mandatory, and we can talk about this now, even if it's to talk about that while we may not approve entirely of the method, the procedure the court followed, we're satisfied in the end result. That could be one change. But yeah, what they're talking about is what we've talked about from the beginning, Charmaine, that one of the answers to this is no, you need to go to trial, and if you lose and you're convicted of something, bring it up then. Mm-hmm. Now, whereas if they grant relief, some have said, well, wouldn't that give an automatic right of appeal to him then? No, because you can't take an inconsistent position. You can't say, I'm aware of all of these things, 1 through 4, is what it's down to now. It's interesting that the judge's brief doesn't mention filing the notice of claim. The AG's office mentions that only that was something that was mentioned in the meeting. So she's abandoned that. I'm pretty sure her attorney said that's done all the time. That's not a conflict of interest whatsoever, preserving a client's right to pursue a civil claim. How could that ever be a potential conflict of interest? And think she's gotten that confused with, you're not supposed to do, well, you're prohibited from doing criminal cases on a contingency basis, like a personal injury case. In other words, you can't take a criminal case saying that if you're found not guilty, the fee's $1 million. If if you're found guilty, you pay nothing. That's how civil cases are done. There's no fee unless we collect. And she may be confusing that somehow. I don't know what her thought process was on that. It was really baffling at the time. I read the transcript that she actually said that, but they're not proceeding with that, apparently, for purposes of this. But no, that's what they're saying, is that you need to go to a verdict and then claim that on appeal. And in Indiana, they apparently they favor trial counsel doing the appeals. So he would have the same attorneys, presumably on a direct appeal. They're not going to be too keen on raising that on his behalf. So, it'll get lost in the shuffle.
On there. Sorry, I don't, just seeing here. Charmaine had said, oh my gosh, so let him be found guilty with all these questions about his rights, then appeal. That sounds ridiculous.
Doesn't it?
Isn't it? That's what my husband always says.
Yeah. So, that's so, you got to commend these attorneys and people like Hennessy, who is the director of that defense counsel, and, amicus, getting in there early and taking a shot. And then, if the Indiana Supreme Court says, no, it's premature, you can raise these on appeal, then, they took their best shot. But I keep referring to the phrase, if that happens, there's going to be this overarching cloud that's going to follow this case, even if it's a perfect trial. There's nothing offered by the defense that's excluded. There's nothing that the state offers that the defense objects to that isn't sustained, meaning they want to bring in this expert about something and the defense says they're not qualified. Court says, I agree. So that, there's literally, which never happens, an error-free trial. There's still going to be this issue that's lingering. But there's got to be something within the zone of reasonable agreement that the judge did that she's clearly prohibited from doing in order for them to act. They can't go so far against the rules that make this a very, very limited remedy to only reversing actions done by a public official that they're required to do, or making them do something that they're required to do clearly under the law that they won't do. They can't deviate so far from that. And that's the thrust of these two briefs are arguing, that, if you start to get into this, then you're going to see petitions for writs of mandamus on all kinds of decisions during the pendency of a case that are just, inappropriate. For example, the court denies a motion to suppress. That's just universally regarded as that's discretionary, and it's inappropriate, completely inappropriate for mandamus relief. And you've got to wait until the appropriate time, which is direct appeal, to argue that should have been granted. And even if the court, looking at it, said, this is crazy, because there's no way the court should have denied this motion to suppress based on this evidence. But they cannot say, well, in this one case, we're going to allow that because it sets a precedent that would invite anybody that lost a motion to suppress to try and do the same thing. So it's a delicate balance. If they feel that there's something that needs to be addressed right now, their opinion ultimately is going to be, they're going to, what we call, narrow it. They're going to narrow it to the facts of this case. They're going to narrow it to the particular situation that they feel warrants granting relief on, and whether that's how the attorneys were appointed, or the mechanism for the notice and opportunity to be heard. They're going to narrow it down to the situation where counsel are removed. You have to do steps A, B, and C, and everything else is not appropriate. That's a really good point, Ben. Nothing to lose by appealing, but that's really not the situation here. It's here what the issue is: if there's a potentially good ground for appeal, and if the court can handle it in a petition for a writ versus waiting for the whole thing to go through trial, should the court reach the merits on it now, or just say, no, the rules prevent that? And so this isn't the case where you can just throw anything you want up against the wall on appeal. There's some things that they're acknowledging in part that occurred a certain way, and the other side saying, no, it needed to go through these steps. So if it has to wait for a direct appeal and it does get fully presented, it's going to present the court with some issues, because we know from that 2000 case, they didn't have to reach the merits on the factors and those sorts of things. So it's apparently, it's an open question of law. And so it's going to have more validity than, the typical issues on appeal.
Here, Travis, I got about 10 more minutes, and then I need to get off because we're on the Drunk Turkey show tonight as well. So if there's any more questions for Travis, you guys, just get them in. Thank you for doing this today, Travis. By the way, of course, I know it kind of came in last minute and you weren't prepped as much as you'd probably like to be. Everyone underneath the sun went live with this at the same time, pretty much, or just before. Mm-hmm. Did you hear me, Travis, or no?
Oh, yeah. You're welcome. Yeah. That's really about all I've got on it. And there's more questions.
We got
to answer those, and then I need to skedaddle too.
Yeah. I guess it's like, because you're 2 hours difference. It's probably almost dinner time for you.
Got stuff from the day. You got
to finish up. Okay. Well, okay, guys. Well, let's do this. Yes, let's do this then. Would Travis? Wait, let me just see what she says here. Would Travis mind to take a look at defense's press release from 2022, which I believe is the extrajudicial statements, and tell us his opinion later? So you're talking about the Judge Diner one, yeah, from November. I remember looking at that. Sleuthy Goosey had it up on her page, which I believe, and tell us. Do you want me to send you those? Do you want me just to send you those papers? Like there's two pages to it, I believe, right, Ivy? Like you don't have to do that now or nothing like that. She's just asking if you'll take a look.
Yeah, be happy to. Yeah, send it to me, and we can talk about that at some point.
Well, yeah, I just want to. 1 second here. I probably screenshotted them when I was on my iPad on there. So she should cancel. 1 second here. Sleuthy. Just go back down here. It was like, Richard. Who? I think this is what you're talking about, right? November 3rd, right? Ivy. One sec there. Okay. Where am I? I'm getting lost in myself here. Different page. Cancel. Why is it only giving me the first page? Stupid. Seriously? How do you screenshot 2 pages and then you only get 1 screenshot? Okay. Percent. Must be this one. Share screen. This is the one I guess she's talking about here. It's not very big, Travis. But I don't know if you want to quickly take a. Oh my goodness.
Yeah, I don't want to rush through that now.
Yeah.
Given the
I'll
questions.
just send them to you, and yeah, I'll just send it to you. They're not. It's just 2 pages on there anyway. If that's one you're talking
I thought
about.
she was talking about the press release,
Oh,
the
let's.
one that they keep complaining about.
Oh, the press release one. Yeah, it's
So we can dig that up, and then I can go through that. And she issued the gag order in response to the press release. That's what
talking
she
about.
talks about in camera. But yeah, send that to me, and I can go
Yeah.
through it and
Okay.
see if it goes overboard or whatnot. But
This one, right, Ivy? Yeah.
the way to handle that is you file a bar grievance, either the state or the defendant. And I haven't even read the indictment in this case. I don't know if they went overboard in the indictment.
Mhm. Okay. I will
And
do.
some of this stuff, um, I don't know, in Indiana, if it's against the rules of professional responsibility to declare your client's innocence or not. I need to see the way they did it in the press release, but
Okay.
they may be, really we need to see what's more important is how it's replied to, if they are going to seek a reply.
Okay. Travis, I sent that to your email just so you know on
Great.
there. Other than that, you guys, Travis, thank you so much again for joining us and going over this. Sorry, I'm kind of out of it today. Little space cadet here. But thank you so much for um, letting everyone hear your thoughts and going over this with us.
Oh, you're welcome. Thanks for having me on the show again. I really appreciate it. I'm probably going to go over to
Thoughts?
Defense Diaries and get their take on it. It'll be more from the defendant's
Point of
perspective.
view,
And I
right?
like to
Yeah.
get all perspectives. Yeah.
Yeah, absolutely on there. But okay, so thank you so much. So I sent you that from Ivy, and then we'll just I guess wait for the response, the reply, I suppose, on there. But other than that, you guys, we'll see you on the Drunk Turkey show for anyone that wants to come over and watch that tonight. I think Daniel and that want to talk about like the leaker information again, Westerman and all that stuff. But anyways, thank you, Travis. You have a great evening. Thank you so much, guys, for joining us. And if you haven't hit the like button, please hit the like button for us. Thank you. Alexa says
All
thank
right.
you, everyone.
Thanks
All
for
right.
having me.
Oh,
Roll outro. Bye.
oh yeah. Okay. Bye. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.